Hello, everyone. It is so great to see such a packed house tonight. Woo, yes. I am going to be brief because you're not here to listen to me talk, but I will briefly introduce myself and give a few housekeeping rules for tonight. I'm just going to give the first one right now because I see some laptops out. Out of respect for our competitors tonight, please immediately put away not just laptops, but also make sure your phone is either on Do Not Disturb or that it's turned off. The two competitors that are here in front of you today worked really, really hard to get here, and they deserve your attention, and they deserve your respect. And I think we can all give that for the next 70 minutes, right? My name's Natalie Winters. I am the Executive Director of the Competitions Program here at Berkeley Law. I also see some of my students in the audience today from criminal law. Thank you so much for being here. We are going to go ahead and kick things off in just a couple of minutes. But first, let me just say welcome to the 2025 James Patterson McBaine Honors Moot Court Competition. This has been hosted at Berkeley Law for over 6 decades, and it's the most prestigious internal competition that we offer here at the law school. So it's a really big deal to have these two folks in front of you tonight arguing to become the champion of McBaine. We're actually going to announce the winner tonight when the oral argument ends. We're also going to hand out awards for the best brief winner, something that was decided before this evening. I will unfortunately not have time to say thank you to all of the amazing staff, students, practitioners, and judges who volunteered their time to make tonight possible, but they are acknowledged in your program, so make sure you take a look at that. From this moment forward, Booth Auditorium is going to be transformed into an appellate courtroom, so please make sure that you treat it with the respect that that deserves. I'm going to stop talking and hand things over to our bailiff, who will begin the moot court session this evening. Thank you for being here, and enjoy.
All rise. The Honorable Chief Justice and Associate Justices of the United States of America. Oyez, oyez, oyez. All persons having business before the Honorable Supreme Court of the United States are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. Well, good evening. I want to welcome everyone here to the final round of the McBaine Moot Court competition. It's a privilege for this panel to be hearing argument today in Hammond. And before we begin argument, I want to just say on behalf of the panel, thank you so much for inviting us to be here with you. This is such a wonderful law school. It's known throughout the country for its reputation for excellence, both in the students and the faculty. And it's our distinct privilege to get to be here with you tonight and to see some real lawyering in action. My name is Dan Bress. I'm a Ninth Circuit judge with chambers in San Francisco, California. I want to introduce first on my left, Judge Veronica Rossman, who is a judge of the 10th Circuit with chambers in Denver, Colorado. And to my right, one of my colleagues, in fact, one of my newest colleagues, Judge Alba, who has chambers in Fresno. And of course, you may know that Judge Alba is a graduate of this fine law school, and it's a privilege to have Judge Alba as a colleague, and it's a great honor to be here in the house of Alba to be hearing argument this evening. So with that, we're going to be hearing argument in Hammond versus the United States, and we invite counsel for Petitioner to please proceed.
Good evening. Can your honors hear me all right? Thank you. My name is Heather Mara DeMocker, and I represent the petitioner, Mr. Rex Hammond, in this matter. I've already reserved 5 minutes for rebuttal.
You may proceed.
Thank you, Your Honor. Mr. Chief Justice, may it please the court. For over 331 million Americans, cell phones are an integral part of our daily lives, and every text, phone call, and routine data connection we make generates something called cell site location information, or CSLI. And petitioner, like the other millions of Americans with phones, reasonably expects to control who can and cannot access this sensitive geolocation data, and feels violated when someone accesses that data without his permission or awareness. However, the Seventh Circuit's decision to the contrary, that accessing this real-time CSLI is not a search under the Fourth Amendment, flouts the expectation of privacy that existed when the Fourth Amendment was adopted and risks turning our phones into ankle monitors, allowing the government to proactively learn our location wherever we may be without judicial oversight or proving a concrete exigency is at hand. Therefore, petitioner respectfully asks that this court reverse the Seventh Circuit on 2 grounds. First, under United States v. Carpenter, petitioner respectfully asks that this court hold that the government accessing real-time CSLI is a search under the Fourth Amendment and subject to the warrant requirement, and where appropriate, its exceptions.
Well, so let's just pause there. So, I mean, you say under Carpenter, but I don't think Carpenter quite answered the case we have before us, or do you contend otherwise?
Your Honor, the issue in Carpenter focused solely on historical CSLI. However, those same concerns about historical CSLI are implicated and amplified in the collection of real-time CSLI. While Carpenter focused on the way that historical or record-kept CSLI can create an encyclopedic chronology of our every movements, real-time CSLI, when collected, still allows a chronology of movements to be created.
Don't you think there's a kind of a big difference between 128 days worth of location data and what we have here, which is something like several hours? I mean, we recognize in Fourth Amendment law lots of sort of ideas of de minimis intrusion or de minimis infringement. Why isn't this just that?
Your Honor, under the Fourth Amendment, multiple federal appellate courts have noted that the length of surveillance is not necessarily dispositive. Under Jones, Justice Sotomayor noted that even short-term surveillance can reveal a wealth of information about our private, sexual, religious, and other professional and political associations.
Is the length of the intrusion relevant to whether it's a search?
Your Honor, it is petitioner's position that the length of intrusion is not relevant to whether it is a search.
Counsel, what about if it's real-time versus historical? With real-time, wouldn't the law enforcement have a better argument to say there were exigent circumstances? We needed the information now because there was a crime being committed now.
Your Honor, the officer's alleged good faith belief that exigent circumstances were present in this case by his own actions show that that belief was not objectively reasonable. However, under the rule that the petitioner proposes, the warrant requirement does allow for exceptions in exigent circumstances. However, the officer's own behavior again indicates that no exigent circumstances were truly present in this case.
Well, what, I mean, didn't your client rob multiple establishments over a short period of time? And why wouldn't it be exigent to try to track this person down?
Your Honor, under Kentucky v. King, there are certain scenarios that trigger exigent circumstances. However, none of those are present in this case. With regard to what Your Honor mentioned about the temporal proximity between the alleged final robbery, the detective in this case, Detective Giringhelli, made the request for petitioner's data, a request that, I will note, that section of the Stored Communications Act did not authorize, but made the request for that data more than 48 hours after the final robbery was allegedly committed. And once the cell provider in this case, AT&T, actually turned over that data, the officer waited for another 2.5, almost 3 hours before not acting on the data personally himself.
So could you envision a set of facts that would satisfy exigency under the circumstances?
Yes, Your Honor. In that case, it could be using electronic data to pursue a suspect who is actively fleeing, to find out where they may be going after a robbery was initially committed.
Does Carpenter speak to this at all?
Your Honor, it is my understanding that Carpenter does not speak directly to exigent circumstances.
Counsel, do you see a difference between real-time pings and historical CSLI?
Yes, Your Honor. There is a massive difference, first, in the way that real-time versus historical CSLI is created. Historical CSLI, or record-kept CSLI, is a proprietary or business record of AT&T or other cell companies. However, real-time CSLI is, first, in no way a stored record, and also is only created at the instance that the government makes that request. Further, while historical CSLI can indicate mere proximity, as this court noted in Carpenter, it can only pinpoint someone within generally a few city blocks. However, real-time CSLI indicates far more precision, with the Northern District of Ohio, as recently as last November, speaking directly to Chief Justice Roberts' fears in Carpenter that this technology has advanced. In that case in the Northern District of Ohio, again, as recently as last November, the suspect in that case was pinpointed with their real-time data pings within approximately a meter radius, allowing someone to be pinpointed even in the short term in an incredibly sensitive place like an abortion clinic, a prison visiting room, or a house of worship like a synagogue or a mosque.
But I don't know that
Go ahead,
Three
Chief.
of us, yeah.
Go ahead, Chief.
I don't know that your client was found in a sensitive place. Does that make a difference?
No, Your Honor. By looking at the fruits of government conduct rather than the government's conduct itself, that essentially can turn the Fourth Amendment into a game of Russian roulette. This court has noted that police need workable rules rather than a case-by-case ad hoc basis to guide their actions in the Fourth Amendment context. Specifically, as this court noted in Kylo and again in Riley, with real-time electronic tracking, police often cannot know where a suspect will be located.
So why isn't your theory of the case foreclosed by knots? I mean, there's no reasonable expectation of privacy in just traveling from place to place, right?
Your Honor, this court has noted in Jones and again in Carpenter that a person has a reasonable expectation of privacy in the whole of their physical movements, and that does not necessarily go away simply because they happen to be in public. To Your Honor's concerns about knots, the police in knots knew for a fact in that case that that respondent would be traveling for the duration of that electronic monitoring on public roads. However, respondent and petitioner agree in this case that petitioner would not have been found but for the electronic pings. Unlike other case law, the electronic surveillance here was in no way amplifying what Detective Giringeli could already see with his five senses.
What is the rule that you want us to adopt?
Your Honor, the rule that petitioner proposes in this case is to apply the warrant requirement to real-time CSLI.
For any duration?
Yes, Your Honor, for any duration.
Even 2 seconds?
Yes, Your Honor.
Okay, the touchstone of the Fourth Amendment is reasonableness, right? So why would it be reasonable to exclude 2 seconds worth of CSLI data? What is the invasion of privacy or intrusion on personal liberty that we're protecting in that circumstance? It seems awfully formal.
Your Honor, police do need these workable rules, these workable bright line rules. And even in a short term, a ping takes approximately a nanosecond to reach someone's phone. And even in the short term, someone may be located in a place that, given the context of their life, may still be incredibly sensitive. Again, like an abortion clinic, a prison visiting room. Further, discrete actions of law enforcement are either constitutional or they are not. We cannot have a larger picture of someone's private life or a larger picture of their life overall if we do not have each of the individual pings, each of the trees in that forest.
So why doesn't the good faith exception, we've been talking about exigency, but why doesn't the good faith exception save the day here for the government?
Your Honor, the good faith exception does not apply in this case because in collecting petitioner's real-time CSLI, Detective Giringeli actually acted outside the scope of what the Stored Communications Act authorized.
But that's before, I mean, this is pre-Carpenter. How is he supposed to, didn't he do the best he could?
Your Honor, as this court noted in Kroll, it is a police officer's duty to enforce the laws as they are written as a member of the executive branch. The detective in this case made the request under Section 2702C4 of the Stored Communications Act, whereas Carpenter focused on Section 2703. However, in making the request under Section 2702C4, even absent Carpenter, the detective made these two errors. First, he believed incorrectly, and the parties agree incorrectly, that the section authorized the collection of real-time CSLI, which is in no way any kind of stored record under the plain meaning of the word stored or of the act itself. Additionally, Section 2702C4 is noted as the exigency exception. However, the officer's actions in this case indicate that there was time to spare, whereas the plain language of the statute says that disclosure may only be all right if there's an emergency requiring that disclosure, quote, without delay. However, again, the officer's actions were rife with delay. While the district court compared exigent circumstances in this case to Dawes, none of the key exigencies in Dawes are present here. There was no hot pursuit, there was no evidence at risk of imminent destruction, and in the detective's own words, there was not a single person he can point to at the time of his initial request under Section 2702C4 or at the time he actually directed other officers to act on that request, to act on that real-time data. No single person.
Is it your position then that good faith doesn't apply because it was unreasonable for law enforcement to read the statute the way that he did?
Yes, Your Honor. That is petitioner's position, as well as given that the officer acted outside the scope of the statute, the good faith should not apply because the error he relied on was his own rather than any other government actor. He did not in this case rely on then binding circuit precedent like in Davis, on a facially valid warrant like in Leon, or on a statute later declared unconstitutional.
Has the Supreme Court ever recognized the applicability of the good faith exception under circumstances like this, where it's just a misinterpretation of the law as opposed to a law being invalidated?
No, Your Honor. This court has never extended Davis to mean that an officer's incorrect interpretation of a statute triggers the good faith exception. In fact, other federal circuits have actually explicitly rejected that application of the good faith exception.
Counsel, does it matter whether or not the law enforcement officer, detective here, whether their violation was purposeful? If they were just saying, we're just going to flaunt it, we don't care, we just want to get this guy? Or is it, I honestly believed that, we were allowed to ask for this information. Does that matter?
Your Honor, the officer's subjective intent should not matter in this case because either way, they still made a deliberate choice to act outside the scope of what the statute explicitly authorized. A way to avoid this constitutional game of chance would be to encourage officers to seek warrants in areas of unsettled law. Further, the Seventh Circuit's position below is also rather curious for another reason. As Justice Alito noted in Jones, as well as Justice Kennedy and Carpenter, if we are concerned about what the American public actually considers to be a reasonable expectation of privacy, we can look to elected legislative bodies as representatives of that view. As Justice Alito noted, they are well positioned to draw lines between policing and data privacy. What makes the Seventh Circuit's position that there is no reasonable expectation of privacy in your real-time electronic CSLI curious is that every single state within its jurisdiction clearly is prepared to recognize a reasonable expectation of privacy in that same data. In Indiana, the state from which this case initially arises, that law applying the warrant requirement to real-time CSLI was actually passed in direct response to concerns that officers were collecting Americans' real-time CSLI without any judicial oversight, the very conduct that the detective engaged in this case as well. Additionally, the Illinois law passed before Carpenter and the Wisconsin law passed after Carpenter both explicitly extend the warrant requirement to cover real-time CSLI. This is also indicated at the federal level as well, where there have been bipartisan efforts, pre-Carpenter too, to protect real-time CSLI, with even the DOJ cybersecurity chief at that time stating that a warrant is required for this kind of electronic data tracking.
How should we be thinking about the state court's views on the issue here?
Your Honor, the state court's views are highly persuasive in deciding what the state laws are highly persuasive in deciding that there is a reasonable expectation of privacy in real-time CSLI, even just within the Seventh Circuit. For necessarily, all the people whose elected officials are within the state of Indiana, for example, would necessarily reflect the views of the people in the Seventh Circuit as well.
What about the state court decisions nationally that are coming out on different sides of the issue? What would you invite us to do? How should we be thinking about those cases?
Your Honor, Respondent actually concedes that this case should be under de novo review. As this court noted in United States versus Ornelas, de novo review tends to unify precedent as well as create workable police rules. Now, The rule that petitioner would advance is again the warrant requirement and its exceptions, as the disclosure mechanism is insufficient underneath the Stored Communications Act, where it actually removes neutral magistrates, judges, the people that we want to be the backstop of our Fourth Amendment rights, from the equation entirely of whether or not to disclose this kind of sensitive electronic data. As this court has noted in United States versus Johnson, police are engaged in the often competitive business of ferreting out crime, and cell carriers like AT&T, which do not necessarily have their own investigative forces or their own information, are in no place to push back against these requests by law enforcement. We do not want private companies or members of the executive branch who are interested in the outcome of their actions to be the backstop of Fourth Amendment rights. Instead, we want neutral...
Let's just pause a little bit here, because one feature of modern life is that everybody knows where everybody is. And your spouse can track you on your phone, and your kids can do the same. You can turn on location services, and most people don't even know how to do that, and they're on all the time anyway. So what is the grand harm here to your client who had himself located, just like I could locate any member of my family through my phone? We maybe once had an expectation of privacy in such matters, but maybe we don't anymore.
Your Honor, as Chief Justice Roberts noted in United States versus Carpenter, it is unreasonable to expect Americans to simply turn off their phones entirely to protect against any kind of cell site information or even GPS data from being provided to the government or other entities. With regard to Your Honor's point about how we have our locations on, we can find our family, our spouses, with Find My Friends is an opt-in program where if we focus on the types of location services that Americans are faced with every day, we can go into my phone, as I have with my family, and choose often by app, by contact, who can and cannot access our data. That is the kind of technology that Americans are faced with. Further, recent research by the Pew...
That's a fair point, but it just again gets to the question of what do we expect in terms of privacy. We do expect not to have somebody barge into our house or our hotel room or lots of different places, but I'm not sure we expect people not to generally know where we're driving by if lots of apps can detect that essentially automatically.
Your Honor, the point about the technology that Americans are used to facing today is that we still can control in the app settings which apps can actually see us, quote, drive by. Now...
Well, counsel, I mean, there's Google Earth, right? I've seen my house pop up on Google Earth. I didn't consent to that. I didn't want that. I mean, there are instances where, yes, there very much is technology that is pinpointing where you are without you opting in.
Yes, Your Honor. While there is Google Earth is not created for a law enforcement purpose. What matters in this case is that the government is asking for this kind of real-time sensitive electronic data with the specific goal of prosecution in mind. This kind of distinction matters in when we decide whether or not something is a Fourth Amendment search, as without any kind of law enforcement purpose, then searches under the community caretaker doctrine, for example, would be permissible. However, in this case, a law enforcement purpose very much matters.
Let me just go back to something that was asked before, I think by Judge Rossman, about one of the key cases in this area, the Knotts case, because some of the discussion we're having and some of the arguments you're making might have been similar to ones that somebody would make in Knotts, except that that case came out the other way. So I guess I return to the question that Judge Rossman asked about, why isn't this kind of the modern day equivalent to that? At least when we're talking about short term. We said already 128 days of historical data, that's different. But and so maybe it would be different if we followed somebody with a beeper for 128 days. But why isn't this more analogous to the beeper case?
Your Honor, the beeper case in Knotts was decided in the 1980s, a time when this kind of electronic cell phone tracking simply did not exist and was not available to the public. As Chief Justice Roberts noted in Carpenter, our cell phones follow us very faithfully with a voyeuristic level of accuracy wherever we happen to go, with most people even keeping their cell phones next to them when they're in the shower. Now, this case is not like Knotts in the sense that police in that case, again, knew for a fact that the respondent would be traveling on public roads. However, police here had asked for that kind of real-time CSLI precisely because they had no idea where he was, and that data was only available through his phone.
So it could sweep in private places. Is that what you're saying?
Yes, Your Honor. As this court has noted in Riley and again in Kylo, the problem with real-time electronic tracking is that it has the capacity to follow us into these incredibly sensitive areas, areas that we have no control over, because this kind of real-time data, and indeed even historical data, is not created through any active action by a cell phone's user, or even any passive action. Now, turning again to the good faith exception. Extending the good faith exception here would actually, in essence, eviscerate the exclusionary rule, whereas this court again noted in Kroll, an officer's job is to enforce the law as the legislator intended it to be written. By extending the good faith exception here, this essentially removes any incentive for officers to actually understand the laws that they are sworn to enforce, obey, and uphold.
Your argument makes a lot of sense after Carpenter, but we're dealing with a pre-Carpenter context. And you need to persuade us that it was unreasonable for law enforcement to interpret the statute in the way that he did to cover real-time CSLI. Why was the interpretation an unreasonable one?
Your Honor, the interpretation was an unreasonable one because there was no binding circuit precedent at this time that first explicitly authorized this kind of electronic data to be collected. And additionally, that section was not the section at issue in Carpenter either. We expect an officer to understand the law and to enforce it as it is written.
So the exclusionary rule is a tool of last resort. You would agree with that?
Yes, Your Honor.
So how would suppression here deter misconduct by law enforcement?
Your Honor, the conduct that we are trying to deter here is we want to deter officers' selective ignorance of the law. By the conduct that we instead want to rather encourage is for officers to understand the plain language of the laws that they are sworn to enforce and uphold.
So counsel, with that point, the SCA covers both, quote, records and I'm quoting now, other information pertaining to a subscriber to or a customer of such service. So why doesn't the real-time fall under the other information pertaining?
Your Honor, real-time CSLI does not fall under the other information in the Stored Communications Act because real-time CSLI is in no way a stored communication. It is only created at the explicit request of government and would not exist in any way otherwise. Additionally,
So what would that refer to then? I mean, was the legislator just being superfluous where they just, let me just add stuff to the SCA just for fun? I mean, what does it apply to then?
Your Honor, that would apply to other types of stored records that are kept in the ordinary course of business by cell carriers like AT&T. Additionally, if we look to the legislative history, at the time that the Stored Communications Act was adopted, the introducing representatives explicitly in their statements did not intend for this act to be used to manage real-time electronic communications. Those were instead covered by other statutes. With regard to Your Honor's concerns about the use of language, this other information or other records. As a judge notes in Wallace, coming out from Texas, most of the case law at that time did not actually interpret the Stored Communications Act to allow this kind of real-time CSLI data, noting that to consider real-time CSLI data as a stored communication would be to simply ignore the plain meaning of the Act's title and of the word stored itself. The rule that Petitioner wants is the warrant requirement, and where appropriate, where there is truly an emergency, its exceptions. The warrant requirement since the founding has proved to be a flexible rule to protect Americans' Fourth Amendment rights as cellular technology does advance. The purpose of the Fourth Amendment, as this court has noted in Kylo, is to place obstacles in the way of too permeating a police surveillance. If allowing the government to learn our location without judicial oversight, without an emergency at hand, in fact, by just consulting with a private company isn't too permeating police surveillance, perhaps nothing else may be. Thank you.
Thank you. We'll look forward to hearing further from you during rebuttal. And we'll hear now from Mr. Gupta.
Sure, that'd be great.
Mr. Gupta.
Thank you. Good evening, Your Honors, and may it please the Court. My name is Hersh Gupta, and I represent the government in this action. Your Honors, this is a case about good policing. We expect law enforcement to apprehend armed and dangerous suspects who pose a threat to our lives and our communities. Real-time CSLI allows law enforcement to do that job more efficiently without creating new privacy risks. And that's because Section 2702 is narrowly tailored to only provide a cell phone's temporary location in extreme circumstances. Widespread government surveillance of the general public is not at issue here. Instead, the question before this court is whether law enforcement can use Section 2702 to access real-time CSLI to help apprehend the likes of the Boston Marathon bombers or a reckless robber. Accordingly, this court should deny petitioner's request for two reasons. First, real-time CSLI accessed for short intervals pursuant to Section 2702 does not raise privacy concerns that would render it a Fourth Amendment search. And second, even if this court were to find that there was a search, the evidence is still admissible under the Krull good faith exception to the exclusionary rule. With respect to the first issue, there are two—
Isn't the consequences of ruling for the government in this case that law enforcement could use real-time cell phone location data to track anyone, anywhere with a cell phone without probable cause?
No, Your Honor. The way that this technology would work, as prescribed by 2702C4, is that when law enforcement in good faith believes that there is an emergency involving danger of death or serious physical injury, which lower courts, the majority of lower courts, have found to be consistent with the exigent circumstances exception to the warrant requirement, only in those cases would law enforcement be able to consider accessing this information.
Counsel, in this case, what were the exigent circumstances justifying the exigency request under 2702?
Your Honor, several reasons. First, there's certainly an emergency when this suspect has committed a series of 7 armed robberies in the span of 3 weeks. And there's certainly an emergency when that pattern of robberies actually demonstrates a greater propensity for robberies, as demonstrated by Hammond's criminal record for the same crime.
But he left the gun behind. So was there a concern somehow that he had another one? I guess I don't understand why it was so important to get it right at that time without seeking a warrant.
Your Honor, the witness records and video surveillance footage revealed that after he had left the gun behind in that one particular robbery, he was quickly able to acquire another one and continue committing the same series of robberies in the same manner. In multiple of those occasions, he handled that firearm recklessly, both by leaving it on the counter during one of the robberies, but also in multiple occasions having his finger on or near the trigger while it was pointed at the store clerks. Law enforcement, given his record and these pattern of robberies, reasonably believed that there was an emergency and that he was likely to commit another robbery soon. And
How much time passed between the final robbery where he left the gun and when the police officers requested the documents from AT&T?
just over 48 hours, Your Honor. And that span of time, contrary to petitioner's claim that it lessened the emergency before the officers, during that span of time, law enforcement actually was diligently reviewing all of the evidence that they had available to them to make sure that it was in fact Hammond who they were trying to apprehend in the first place. And this set of facts is very similar to the ones the Second Circuit in the United States versus Gilliam recognized in 2016, whereby law enforcement, 2 days after learning of a suspect's threat to a young girl, started soliciting that suspect's location information, but the emergency was still present under the 2702C4. And in this case, the language in C4, that good faith language, actually amplifies the reasonableness of a request made under that statute because it requires law enforcement to put in the investigatory legwork to make sure this is in fact the person they're trying to apprehend. So that statute, just like under the existing exigent circumstances doctrine, requires law enforcement to review evidence available to them, in this case video surveillance footage, witness accounts, DMV records, and it was actually only through that information that law enforcement was able to learn of Hammond's phone number to begin with. So there's both a practical check here, where law enforcement first needs to do that investigatory work to even get the phone number, to have a chance at soliciting this person's phone, rather real-time cell phone location, and also a statutory check in that the law enforcement must be going through that process in good faith.
But our
Please.
Thank you, Chief. Our decision in Carpenter makes it pretty clear that the standard in the statute is obviously not the same as the Fourth Amendment standard. What are we supposed to do with that in receiving your argument.
Your Honor, I believe Carpenter deals with Section 2703, which is a different section than what law enforcement relied on here, which is 2702C4 in particular. And another difference between Carpenter and in this case is the difference between historical and real-time CSLI. And contrary to petitioner's claim that historical CSLI is less violative, it is actually significantly more violative exactly for the reasons Your Honor's put forward, in that it allows law enforcement, in Carpenter, for example, to be handed over in bulk something on the order of 127 days in that case of location information, which they then at their leisure are sorting through and reconstructing patterns of movement, patterns of association. And as petitioner says, yes, we have a right of privacy right, a reasonable expectation of privacy in the whole of our physical movements. But that's what the aggregation and assembling of information reveals. By stark contrast, it is precisely because real-time CSLI is directly solicited that law enforcement only is getting the information they need to apprehend this person as quickly as possible. And again, in these circumstances, to compare it to what our existing regime is, in the exigent circumstances doctrine, law enforcement has identified their prime suspect, and then once they're justified in apprehending and searching for this person, we expect them, in the interest of public safety, to do that as quickly as possible.
So how long were they actually receiving the real-time data here?
Your Honor, in this case, it was a matter of just a few hours.
Okay, so would you agree that there is some point where this becomes too long?
Yes, Your Honor.
Okay, what's that point?
Your Honor, this court has actually already drawn that line in Carpenter. In a footnote, this court pointed out that 7 days worth of historical CSLI is probably where that reasonable expectation of privacy starts to cross into unreasonable expectations. And this lower courts have actually been comfortable applying that 7 days threshold to real-time cases. For example, Sims versus State from the Texas Court of Criminal Appeal. The judge there reviewed the facts similar to this case, where a few hours of real-time CSLI was solicited and looked to that 7 day threshold to determine that.
But where is this? I mean, apparently we said it, but where is this coming from? Is there some historical foundation for this? Is there some other legal foundation for why 7 days would be the benchmark?
Your Honor, in a realm where privacy expectations are constantly shifting and evolving with our digital technology, that's what the Carpenter Court at that time determined to be a reasonable expectation.
So how can there be a reasonable expectation of privacy in where you have been but not in where you are?
Your Honor, just to understand, so it sounds like the difference between historical location versus
Yeah,
real
it
time.
just, yes, that is my question. I mean, I want to know more about why the government thinks that that's a important principled distinction that would drive the rule in this case.
Your Honor, it's less the distinction between your past movements and your present movements, and more that the nature of historical CSLI, when it is transmitted to law enforcement, is something that's done in bulk and gives law enforcement substantially more data to draw from to piece together your patterns of movement and association. Whereas real-time CSLI, law enforcement has to actively go and solicit each ping, and that makes that information far more tailored to their process of actually just apprehending a person as we'd otherwise expect them to do.
So, counsel, I have a question because I was a trial court judge and I had to sign warrants quite often. I don't understand why, for the historical data at least, or why it is that they felt that they didn't have enough time to get a warrant. It doesn't take very long. They write a quick, affidavit, and then he clearly, the detective here clearly had information already because that's how he was able to go and request the information from AT&T.
Your Honor, the timing of the request is certainly important here because once the timing of the 48 hours between when law enforcement learned of the latest robbery and when they first started soliciting the information is the time during which law enforcement was actually reviewing that information in order to even establish probable cause to begin with. And as soon as they know, they go. And this is something that, yes, in some cases, they should go and get a warrant should there not be as exigent circumstances present.
So let me make sure I understand you. Are you saying that they did not have probable cause when they asked AT&T for the information, or they already did have probable cause when they asked AT&T for the information?
They did have probable cause when they...
So why couldn't they have asked a judge? If they already had probable cause, they just had to write the affidavit, make the phone call, ask a judge for a warrant. Why is that asking too much of law enforcement?
Your Honor, in general, the government's position is that law enforcement should continue to get warrants in the same manner that they already would. The only reason here that law enforcement did not need to go through that process was because there were these exigent circumstances present. And so as soon as law enforcement narrowed in on their prime suspect, that who it was that they needed to track down and apprehend, they sought to seek that person out as quickly as possible in the same manner that they would have brought squads of helicopters and cop cars to do the same using traditional law enforcement methods. And so again, this is no different from how law enforcement would operate in an existing exigent circumstances regime, because even where in cases where it may take a little bit of time to determine who it is that their prime suspect is, as soon as law enforcement decides that that is in fact the person they're trying to apprehend, again, we expect them in the interest of public safety to be pursuing them as quickly as possible when an emergency truly exists. And when there isn't, they should absolutely be getting a warrant consistent with how this court has ruled in the past.
I guess my concern is stemming from the fact that what I'm hearing, or maybe understanding from you, is that it takes a while to get a warrant. My point is, it doesn't. If you already had probable cause going in, you had the time. It's an affidavit. You write the affidavit. You say, affirm under penalty of perjury that these are the facts that give rise to probable cause. So, Judge, please let me go get this information. That would go a long way to protect the privacy of people, and you wouldn't even be here today because of that. So I'm not as flip with it as I feel you are being about the information and how they got a hold of it, and that they didn't have time for a warrant.
Your Honor, I think it would be a fact-specific inquiry given when exigent circumstances exist. And in this case, when law enforcement determines their exigent circumstances, this court has held that it is constitutional for them to pursue that person as quickly as possible without getting a warrant. And again, it's the government's position that in cases where that doesn't exist, as Your Honor mentioned, it is quick to get a warrant, and they should absolutely be doing so and continue to pursue them to apprehend, in that case, somebody who has committed a crime but doesn't necessarily pose the same danger of death or serious physical injury as the person here does that creates the exigent circumstances. So it's particularly because they believed Hammond was about to commit another robbery, which, as the facts and record make clear, he was in fact on his way to do, that led them to believe that they needed to spring into action as quickly as possible to pursue him.
So earlier, when I asked your friend on the other side about exigent circumstances, one of the examples that counsel gave was, somebody in hot pursuit. We don't have that here. You said it's 48 hours, right, in between when they had the information and then when they made the request to AT&T?
Yes, Your Honor.
And 48 hours you feel is exigent so that they don't have to go get a warrant?
Your Honor, this was a case that involved several different states, several different state law enforcement departments, and Hammond had been committing these robberies in multiple locations. And so, yes, law enforcement was hoping to apprehend whoever was responsible for these as quickly as possible. But as efficiently as they could, they needed to look at the evidence they had available to them, figure out that it was the same person who was responsible for all of them, and deploy their forces as quickly as they could. So the exigent circumstances here existed in the sense that once they narrowed down through this coordinated effort, given the nature of the crime, who it was they were trying to track down, they went after him as quickly as possible. And this would be the same sort of technology we would have maybe used to great effect in the case of something like Luigi Mangione, where officers had an idea of who it was, but they needed to collect the evidence. They turned New York City inside out to try and find this person when after having decided that it was him they were trying to apprehend, a simple ping to his cell phone would have honed the search in a way that would have led to his apprehension much more quickly and given our been in the interest of public safety.
What happens if the real-time data reveals his locations and places where he does have a very much a reasonable expectation of privacy? Like if it's tracking him to his home or to his family's home or to a house of worship or something, would that be a different case?
No, Your Honor. And that's because the possibility of finding somebody in that intimate location is exactly why this technology is narrowly tailored to only be used in cases where law enforcement is already justified in apprehending this person. And so that temporary glimpse of potentially private location information is exactly what is consistent with how law enforcement already operates in traditional methods.
Well, do you think that the real-time data here revealed any such private place, or is your position that it actually didn't?
No, Your Honor. In this case, it did not because Hammond happened to be on public roads. But the government contends that even if that distinction is not necessary for this court to conclude that in exigent circumstances, this technology can be used as an assistive tool to law enforcement. That's because once law enforcement has identified who you are and where they need to go to try and apprehend you, they're using their full arsenal to try and find you. And it's possible that with traditional methods, absent any of this technology, they may still find you in that potentially private place. And in Warden v. Hayden, this court found that if exigent circumstances justify law enforcement being able to search for them, they may even be able to search for that person within the home too. And in those cases, you might have, the suspect might have much more private things in that home, like what's on your computer, what's cooking on the stove, other people in the home, all of which law enforcement is taking in through their five senses. By contrast here, the location ping actually filters all of that other information out and only gives law enforcement the information they need to hone their search and apprehend that person as quickly as possible.
Well, you just mentioned the word search, I think maybe for the first time in your presentation, maybe not the first time, but we haven't really talked about that feature of this. And we've been talking a lot about exigency and about good faith, but on the pure threshold Fourth Amendment question, when the government asks cell phone providers to provide real-time location data, just like when they've asked for historical, why isn't that in and of itself a search?
Your Honor, it's not a search for law enforcement to ask for this information pursuant to the terms of Section 2702C4, where they in good faith believe that these exigent circumstances exist, because just as they would with traditional methods, once they've established who it is they're trying to find, it is their job. We expect them, and it is reasonable for them to pursue that person as quickly as possible, even if that search ends up finding that person in a potentially private location. And so all this technology is doing is not helping not that initial process of learning more about the person, trying to gather information to hone their determination of the prime suspect, but rather when they've made that determination, this technology is only being used under 2702C4 to accelerate the search that they would already be undertaking using traditional methods.
If we think there were not exigent circumstances, do you then lose?
No, Your Honor. In those cases, the government should get a warrant. But there's no
Okay,
reason.
but you don't have one here.
That's correct.
So do you lose if it's not exigent, or do you lose this case if it's not exigent circumstances?
No, Your Honor. And that's because the good faith of the officer still plays a role here. So even if even if this court were to find that there was a search and that maybe there weren't exigent circumstances, because Detective Girangelli relied in objectively reasonable good faith on 2702C4, the evidence is still admissible under Krull. And that's for a few reasons. The first is that, contrary to petitioner's claim, real-time CSLI is well within the contemplation of the statute. The statute's terms are consistent with the Fourth Amendment. And third, Detective Girangelli's reliance was also consistent with judicial precedent at the time. To that first point, the term stored is meant to be a term that generally refers to any information communicated from a person's phone to their provider. And that's made clear in the general protection design of the statute, which governs all types of communications and information from a person's phone, and further amplified by Justice Alba's observation earlier of the or other information language in 2702C, which is intended, again, to govern that communication of location information from the phone to the provider. And even if this court were to reject that interpretation, when that location ping is communicated from the phone to the provider, it becomes a record, however instantaneously, in the possession of that provider. Furthermore, petitioner cites to some statutes in the states within the Seventh Circuit that have governed the use of real-time CSLI. What petitioner fails to mention is that all of those statutes were passed after the real-time CSLI was solicited in this case. And while the legislature may be a place that captures shifting political and social attitudes, law enforcement should be expected to respond to those in the form of enacted statutes, not political rhetoric. We expect law enforcement to abide by the Constitution. We expect law enforcement to abide by otherwise constitutional statutes. And in fact, as this court said in Krull, we also expect law enforcement to deny to follow clearly unconstitutional statutes, but to expect that law enforcement is going to react to, at an individual capacity, live political discussions that may not ultimately find their way into enacted law would be to turn our system of government on its head. Law enforcement should not be making laws, they should be enforcing them. And further, the statute is structured as a general prohibition against releasing any consumer phone records whatsoever, subject to very specific exceptions. The difference between C6 and C4 amplifies the fact that the statute is in fact constitutional. In C6, the statute says that any person other than a government entity can access this data without any additional guardrails. And a cursory glance between that and C4 reveals that for the government to do the same requires significantly more of that government entity, including just being consistent with this exigent circumstances exception. And so a cursory glance at the statute would have led Detective Girangelli to believe that he was in fact acting constitutionally. Further, the detective's interpretation of the statute was consistent with judicial precedent at the time. As Justice Rossman noted earlier, the Supreme Court had not yet decided Carpenter at the time that Detective Girangelli was soliciting this real-time information, nor had any circuit in his jurisdiction made a decision with respect to historical CSLI, let alone real-time CSLI. However, at that time, the 11th and 5th circuits had both ruled that historical CSLI could be accessed without a warrant. So Detective Girangelli, looking at those precedents, may have been inclined to believe that historical CSLI, which again is significantly more violative than real-time CSLI, allowed him reasonably to access real-time CSLI without a
Why do you,
warrant.
I mean, you keep saying this, that the historical data is more violative, but is it necessarily true? I mean, or at least true in every case? Because somebody could have some historical data that's kind of uninteresting. They could have some real-time data that's very intrusive. Like, why is this distinction matter so much in your view?
Your Honor, it largely has to do with how this information is collected and communicated to law enforcement officers. So in the case of historical CSLI, because it's ordinarily collected in the course of business of these cell providers, that doesn't mean we expect it's being disseminated through that cell provider to third parties, but it does mean that when it's communicated to law enforcement, it's communicated in bulk. And so when law enforcement gets it, they're sifting through all of this information, some of which, as Your Honor suggests, may be uninteresting, but all of which is something that law enforcement now has their hands on and can piece together patterns of movement and association that reveal the whole of your physical person. And so by contrast, real-time CSLI, because it's being actively solicited at each ping, law enforcement is only getting the information they need to facilitate their pursuit of a suspect they're justified to pursue. And so, yes, it's possible that
Doesn't the real-time data become instantaneously historical, as soon as we have it? As soon as a law enforcement agency has it?
Yes, Your Honor, that is correct, but the reality is that that nature of historical CSLI, because it's been actively solicited, is all information that law enforcement actively needs and is narrowly tailored to their objective.
Yeah, but I guess this makes me wonder whether the distinction is less historical versus real-time and just more about the quantum of data total. That maybe we think that 128 days of data, whether it's real-time or historical, that's just too much, but maybe 1 hour is not too much, and that would be true regardless of whether it was historical or real-time.
Yes, that interpretation is correct, Your Honor. The government would agree with that. And so, but the reason why we're categorizing it in this way is because of the volume that's communicated through a historical request is significantly more than the single pings of information that are communicated.
Right, but I mean, this does get to one question I would have then with your position, which is where do you forget about the footnote about 7 days, because I'm not sure we were fully thinking about the case like we have now, but 6 hours is not 6 minutes, right? And so 6 hours of real-time data is, enough to really show where somebody is, a lot about a person. So why wouldn't somebody have a reasonable expectation in that amount of data, even if they don't have a reasonable expectation in 6 minutes worth of data?
Your Honor, the 6 hours of data, well, first to answer your general question as to where we might start to draw this line, in every single case at the federal and state levels that have grappled with the issue of real-time CSLI or even GPS tracking information for that matter, law enforcement has never used that for longer than 24 hours. So there's already a practical threshold there because law enforcement is only using it again to supplement an on-foot physical search. And to the point about the difference between 6 hours versus 6 minutes, I think this would be a fact-specific inquiry. If the exigencies of the circumstances are such that law enforcement is struggling to find this person and needs more time, that's something where the 6 hours could be helpful and still not be invasive of our privacy, in part because 6 hours selected at random is still significantly less information than multiple days on end. It's possible that within those 6 hours, you're doing things that you might not ordinarily do in the course of your day, whereas with historical data where you have weeks of information, you might be able to piece together more patterns of how you actually live your life. And so yes, the 6 hours may find you at intimate locations, but the government is not using this information to surveil you. They're truly using it to facilitate their process of apprehending you. And that is enforced by the statute itself, which says in 2702C4, it says that the data that's disclosed must be related to the emergency. So if the law enforcement starts to bleed over from simply using this to facilitate and hone their search, to start watching you at will, that would run afoul of the statute. And because the statute is consistent with constitutional reasonableness under the Fourth Amendment, that would run afoul of the Constitution.
So is it the government's position that the portion of the statute that was at issue in Carpenter differs from the one before us because the one before us requires more of an individualized assessment? Is that the government's position?
That's correct, Your Honor. In a few ways. Number one is the good faith language in that statute. Number two is that the exigent circumstances language is clearly present in that statute. And the third piece is that the data must be directly related to that emergency. And now the government would further contend that even if this court were to find that Detective Giringhelli's good faith reliance was not objectively reasonable on the statute, that a subjective inquiry into his good faith would be acceptable because at most his conduct was at most negligent. And this court should only extend that subjective inquiry into cases where the good faith is at most negligent. In Calandra, this court said that exclusion is a judicially created remedy only to be used where the benefits of deterring future officer misconduct outweigh the costs of barring relevant evidence from trial. And because the government would contend Detective Giringhelli relied on objectively reasonably relied on a statute that was not facially unconstitutional, that was consistent with judicial precedent, his interpretation was objectively reasonable or at worst negligent. And deliberate, reckless, or grossly negligent police violations of the Fourth Amendment are the cases where we should be focused on using the exclusionary rule because there's flagrantly unconstitutional conduct there that's worth deterring. By contrast here, yes, there is a deterrent effect by deterring negligent conduct, but this court said again that the benefits of the exclusionary rule vary with the culpability of law enforcement conduct. And so calibrating that use of that rule to only cases where the law enforcement truly is acting afoul of the Constitution is where this court should go. And further, a subjective inquiry into good faith would close a loophole this court was concerned with in Leon, whereby an officer who had actual knowledge that their conduct was unconstitutional would be able to admit the evidence, where a, quote, reasonably trained officer, through an objective standard, would not have had such knowledge. And so in this case, we actually make sure that, number one, we're making sure there's an objective inquiry into the officer's good faith, and number two, a subjective inquiry bolstered by corroborating that subjective assessment in the officer's mind in the same way that we evaluate mental state in the criminal law would allow us to make sure that we're not only getting the officer's true intent, but doing so in a way that is consistent with the Constitution.
So just to clarify, so if the officer's belief was objectively unreasonable, but subjectively genuine, you would say the good faith exception should apply?
Not quite, Your Honor. Only in cases where the officer's good faith was not objectively reasonable, but at most ordinarily negligent, should this court extend the good faith exception. If the officer's conduct is any more deliberate, then the use of the exclusionary rule is appropriate because, as this court observed in Herring, the use of the exclusionary rule should vary with the culpability of the law enforcement's conduct. And so to conclude, Your Honors, this court should reject a sweeping proclamation on the Fourth Amendment in Petitioner's case and instead focus on applying the use of this technology only to the cases where law enforcement has already established probable cause to believe this is the individual they're pursuing, and exigent circumstances are present justifying a pursuit using traditional methods, and that this technology would only come into play to facilitate that search, speed it up, and make sure that we're snuffing out this threat to public safety as quickly as possible. Thank you.
Okay, thank you, Mr. Gupta. We'll hear rebuttal.
Your Honors, 3 points. First, factual corrections to the record. At the time of the exigent circumstances requests, the detective could point to not a single person, contrary to a respondent's position, not a single person at risk of death, injury, or in immediate harm's way. Additionally, no one was at all harmed in the commission of these alleged robberies. The record is indeed silent on whether or not the gun was even at any time loaded. AT&T further, with regard to respondents' contention about that real-time CSLI is very temporally limited, AT&T would have continued providing these real-time cell pings up until the moment that someone was found. Additionally, with regard to respondents' contention that we should disregard the recent state laws in the Seventh Circuit protecting real-time CSLI, if anything, these show increased concern from the American people about the protection of their electronic and real-time data. Now, with regard to that electronic real-time data, but respondent focuses mainly on the bulk collection of this data. However, there is no connection with our expectation of privacy, whether we are surveilled for, say, 26 days or 27 days. Either way, we still feel violated. Now, at the founding, we did not necessarily expect a constable to, quote, secret himself in a coach to follow around the coach's owner and our every movements. Likewise, we don't expect our cell phones to reveal with this voyeuristic accuracy our every movements to law enforcement or this, quote, secret constable. As Your Honor precisely noted, a lot of these same real-time data pings may eventually become historical, where under Carpenter, they would still be protected. Even these short-term pings can still reveal very detailed, even in the span of 6 hours, as Your Honors noted here, a wealth of information about our very private and personal lives. While respondent focuses on this as a tool for law enforcement efficiency, this court has never equated efficiency with constitutionality. Real-time CSLI is in no way narrowly tailored, unlike respondent's contention. It is unlimited in its geographic scope, allowing the government to locate us wherever we may be, in private, in public, anywhere. The Fourth Amendment protects people and not places. This is a proposition noted in Katz and affirmed time and time again in DeRay, in Kylo, and in Riley. Now, respondent focused much of his argument on exigent circumstances. However, contrary to respondent's contention, this was in no way a, quote, as soon as they know, they go scenario. Indeed, the officer waited almost 3 hours before acting on the real-time CSLI data provided by AT&T. Additionally,
Counsel, I wanted to touch upon your first point that you made, that no one was harmed. And I agree in that no one was shot, but to say no one was harmed, I think that's probably not accurate. I mean, someone had a gun pointed at them, someone was just trying to go about their day at work, and all of a sudden somebody intrudes upon their feeling of safety. I mean, they felt violated. You're telling us about feeling violated because someone looked at your, real-time cell phone pings, but there was a harm. So by you saying there wasn't one for purposes of exigent circumstance, I guess what I'm asking is, are you telling me that only when there's a physical harm is there an exigent circumstance available for the law enforcement officers?
Your Honor, exigent circumstances have only been found in instances of physical harm. And additionally, we have no evidence in the record that the gun was even pointed at another person. With regard to deterrence, respondent explicitly conceded that there is a deterrent effect here in applying the exclusionary rule, where this failure to apply the exclusionary rule would essentially invite officers to defy the plain language of a statute as written unless explicitly restrained by courts, which would be a further drain on judicial resources.
What is your response to your friend's argument that this isn't standardless because courts aren't having a hard time interpreting Carpenter and applying kind of the benchmarks in Carpenter, and that I understood your position as suggesting that we want more guidance, not less guidance. So what is your response to his argument that we see state courts being able to implement the directives from Carpenter?
Your Honor, the uncertainty here is key, where given state courts implementing the directives from Carpenter, we want to encourage these state courts and courts all across the United States to have officers do the reasonable thing in cases of unsettled law, or, as Respondent notes, cases of intense political discussion, to get a warrant. I see I'm out of time. Thank you.
Thank you. That concludes argument here, and as we say, this case
Round
is
of
submitted.
applause for our finalists, folks. Well, Hersh and Heather, I think you should both be very proud. That was definitely the longest applause I've ever heard for a McBaine oral argument final round. Yeah, woo. Judges, you can go ahead and exit stage right. I'll see you up at judges' headquarters. Folks, again, out of respect to the hard work of not just our finalists tonight, but also the other McBaine competitors who are here and receiving awards, please don't leave until the conclusion of the event. Next, you're going to hear from Jacob Cantor of the law firm Crowell and Mooring, a local firm here in the Bay Area that has sponsored the McBaine competition over the years. He also happens to be a Berkeley Law alum. He's going to come on up here and present the Best Brief Awards. There's one for Petitioner and one for Respondent. While he's talking to you all and presenting those awards, I am going to go chat with our judges. We will be back in about 5 to 10 minutes to announce the winner of this year's McBaine. So sit tight, stay tuned, and I'll check in with you again soon.
Hi, everybody. Hi, everybody. Hello. Hey, round of applause for Natalie. Oh, my God. No. Natalie, so amazing. We graduated in the same law school class together in 2018.
That's true.
Long old friend.
We were actually in the same, I'll get out of your hair in a second, but we were in the same small mod together as 1Ls. And Jacob was really a philosopher in the back row of the torts class. That was with Professor Syed, by the way, for those of you who had him.
Yeah, okay, cool.
All right, I'm gonna get out of here. Thank you, and since I'm getting a shout out, I really can't take all the credit, really any of it at all. I'm really just kind of, in a lot of ways, a figurehead for the competitions program. There are so many incredible people, from my staff teammate, Evie Nevin, who I know is running around here somewhere getting ready for the next event we have right after this. She does so much to make these events possible. There's student directors who get involved. There's folks who are volunteering their time. So I appreciate it, but truly, cannot take the credit. But thank you, and good to see you. We'll chat more at dinner. Be right back.
Hi, everybody. My name is Jacob. I'm a counsel at the law firm Crowell and Mooring in the San Francisco office, and my practice covers IP, privacy, AI, cybersecurity, and I do counseling and litigation in all those areas. And if anyone has questions about those areas of law or practicing or how practicing is different than law school, I'm around, happy to chat about any of those things. It's very nice to meet you all. And a big congratulations to our two oral advocates. You both did just an extraordinary job today. It's really impressive, so good. And even though they can't hear me, I'm gonna get in trouble if I don't say it. I'd like to thank the judges for taking their time to participate in the final round, and all the students for participating in the McBaine contest. It is incredibly important that you learn how to write. It is how you are evaluated as young lawyers. It is how you express arguments to partners, clients, opponents, and judges. It is how you build credibility in the legal community. Today is about writing briefs, But if I can leave you with just one piece of advice, it is that right now, it really does not matter what you write. Write briefs, or write a lot of emails, or write a letter, or write a post on Instagram. Just keep writing. Build your voice. Build confidence writing words that the public will see and will scrutinize. Build your skill so that thoughts in your head can be clearly expressed on the page. All the briefs that we read in the final round were excellent, but we are only allowed to award one Best Petitioner brief and one Best Respondent brief. So, the award for Best Petitioner brief goes to Kayvon Saifnuraji. I'll say the other one too. And the award for Best Respondent brief goes to Hudson Show. We have awards here if you want to do the thing. Yeah. We actually have awards, and I think you take a picture with me or something if you want to do that. So, yeah. Our part's done. You can talk now. Yeah, thanks.
Loving the incitement in here tonight. I heard there was a raucous applause for Best Brief Awards, so thank you for showing support to those folks too while I wasn't here. All right, so we are getting close to announcing our winner. I'm about to welcome in our judges right now. If you could go ahead and send them in, Ivan, thank you very much. Before we announce tonight's winner, we're gonna give all of you a chance to briefly hear from our judges about what they noticed in tonight's oral argument, what they thought went well, and any constructive feedback they have for our finalists. This is really important for all of us to pay attention to, right? Because these are real sitting judges who do this for a living day in and day out. You might appear in their courtroom one day, and they're about to tell you what they think makes a great oral argument, okay? So please give them your attention and your respect. Once they're done with their feedback, I've asked them to keep it to just 5 minutes apiece. And then we will go ahead and, without further ado, announce tonight's winner. So, with that, I'll see you.
Okay, well, we're back and the Inquisition is over, and we can now have a great discussion about some of the wonderful things that we saw here from our two competitors. So I'll ask Judge Rossman to kick it off with her thoughts.
All right, thank you, Chief.
Oh, yeah.
Last time I call you
Yeah.
Chief, right? Wow, really, you both were just unbelievable, truly outstanding, just very, very impressive. And I come to my remarks in two ways. Before I had my current job on the 10th Circuit, I was an appellate federal public defender for many, many years, practicing in front of the court where I now sit. And so appellate advocacy is very challenging. And it seems like you two are welcome in the 10th Circuit anytime, okay? I'll just go over a couple of observations that I wrote down. Both of you had excellent poise at the podium. You were relaxed but serious, which is a tough, sweet spot to be in when you're presenting, because you can't be too scripted. You have to listen, and you have to look like you're listening and look like you're engaged, and you both were able to do that really effectively, and it became more of a conversation because of your excellent demeanor, which I know is born of preparation. So kudos to you for that. On the preparation point, you both had a really tremendous understanding of the law. I was really impressed. The cases, but also the nuances in the cases, distinctions between cases. And we asked you some really challenging doctrinal questions, and you demonstrated such facility with the law, and I was really impressed with that. Similarly, with your knowledge of the facts and the record, it seemed to me like you knew the weaknesses of your cases, but were able to sort of marshal your arguments and work with the record that you had in a really earnest way. And that came across and was also, again, impressive. But I think the two things that were common to both of you that are just things you really see in outstanding appellate advocates, you were helpful. You were trying to be helpful to the court. That is really, I'll speak for myself, but I think that's what judges want. We just want to understand your arguments so that we can figure out why you should win. And if we don't know what your argument is, and if you're not being helpful in explaining it, makes it a lot harder to understand why your position is the availing one. And you both demonstrated a real interest in being helpful. And you were really good with the questions from the court. You're just really great with answering the questions and pivoting when you needed to. And I'll just say two things, one about each of you that I thought was particularly special. With your rebuttal, Heather, you're just, rebuttals are so hard. I always ran out of time as an appellant. I never got to do rebuttal because I never managed my time well. But your rebuttal was just really sharp. You responded with clear points. You made us want to listen to exactly what you wanted to say because you were just ready to go. You responded to your opponent's position, like you were listening to them too. It was really well done. And Hersh, I was impressed that you had a really consistent theme. You came in your opening and you wanted us to see the case a certain way. And that was very effective. And you sort of maintained that refrain throughout. So overall, I know I've already talked too long, but I'm just so deeply impressed with your work and really commend you for the effort and the presentations tonight.
Great. Judge Alba.
Well, thank you. I want to echo everything that Judge Rossman just said. You both were fantastic. And you're also welcome to the Ninth Circuit whenever you'd like to come. A couple of things I'd like to say is your temperament was outstanding. I needled both of you. I asked questions. I made exaggerated faces. I raised my arms. And neither of you took the bait, which I have to say is pretty phenomenal because I always take the bait. I'm terrible. I have the worst poker face on the planet. So if I'm not following you, you'll see me go. So very good that neither of you kind of fell for that, didn't get, defensive, didn't, take that bite. Another thing I wanted to say that you both did that was phenomenal was we fed you back what we thought you were trying to say. We purposely sometimes were not accurate with that. And we just wanted to see if you were paying attention to what it is that we were asking. And you both clarified in a very respectful way. Well, not exactly, Your Honor. What I'm saying is, which is very appreciated and very indicative that you know your stuff. Because a lot of times people are so nervous that they're just like, yeah, I want to agree with the judge because I don't want him to keep asking me questions. So I really appreciated that from both of you. You were very well prepared. It was very obvious that you were well prepared. And honestly, although, yes, we could tell that you had some nerves, which is normal, it looked like you both had some fun up there. So I'm happy about that for you because, that's not always the case. So I'm not going to belabor it. I know Judge Rossman did a great job of laying it all out there for you, but I did just want to make a big point about telling you good job on not taking my bait and keeping really good temperament and good facial expressions. I mean, you did eye contact with me, with all of us, which is very good and very engaging. So congratulations to you both. Great job.
Thank you, Judge Alba and Judge Rossman. I will fully agree with these comments, and I think we saw an extremely high level of advocacy here tonight, and that's it's really impressive. I'll say a couple things, a couple observations I had about the performances, and some observations about oral argument generally. I think what you saw tonight, especially if you're 1Ls here. How many 1Ls are here? Okay, there you go.
Wow.
So for the 1Ls, what you saw was intense amount of preparation because anybody who has to go and do one of these and is going to do it right has poured hours and weeks into what turns out to be 20, 30 minutes of real time, to use a word from the case, live fire, and it really is the practice and the moot courts and the time when you're on a walk and you're practicing and all of those things that go into the performance, because it's really not feasible. I mean, some people do this, but neither of you did, which is they kind of write down what they want to say, and they have in their mind, like, this is how this is going to go. And there's no contingency plan, right? There's no contingency plan for what if they don't agree with me on some of these points. And then there's an immediate drop off because the person has nothing else to go with. What you guys did, which was so great, was that you had kind of prepared for different eventualities. You had in your minds what you wanted, of course, but you had thought carefully about, if they go this direction, I'm going to go that direction. Here's how I'm going to respond to that. And the only way you can do this is by intense amount of preparation. So that obviously was reflected in both of your performances. I thought, both of you did a great job on something that seems easy but is actually really hard, which is just answering the question, and that's a common shortcoming in advocacy is people who are asked a question and who don't really answer it, either because they don't want to answer it or because they're not actually listening. And I think one of the most difficult aspects of oral argument is that a lot of what you're doing is actually listening, and so it's really hard to be on while you're also listening, but the people who are really good at it are listening, and they're being responsive to the court, and both of you did that at a really high level. I didn't feel like you were trying to get out of something or that you weren't capable of responding. So I thought that was really well done. The other thing I'll say is that once the case gets to oral argument, some of the features of the arguments that start to resonate, I think, a little more in the argument are things like, why is this fair? Why is this equitable? Why is this practical? How is this going to work? Like, those are the things that they come through in the briefing, but the briefing can be more about, the legal authority and the legal foundation. And when you get into oral argument, sometimes all of a sudden you're faced with, okay, well, gosh, does this mean somebody's going to be able to be tracked wherever they go? Or on the other hand, does this mean someone's never going to, even 2 minutes? So that sounds awfully extreme too. So, there's lots of questions about how this is all going to work. And I thought both of you were very well prepared, on that front as well. And sometimes advocates come in and think like, well, I'm just going to argue this based on a case, and they kind of forget that what we're thinking about here is not just how to resolve the case, but especially at the appellate level, what is the rule of law going to be? And that's a lot of times what we're thinking about is like not just how do you decide this particular case, but how is this case going to fit into a broader legal framework, ideally, so that like cases can be treated alike. And that's kind of part of the enterprise of appellate decision making. And I thought both of you were kind of, to use Judge Rossman's phrasing, helpful in kind of thinking through the parameters of the legal problem. I thought you both had some really good moments. I always try to write down great moments. I thought I agree that the rebuttal was a very strong moment. When you got up and just kind of hit your points, and I thought that was a successful end, and it was borne out by the fact that you got few questions. I think ideally the rebuttal is. You had 5 minutes. Some people would, won't have that luxury. They might have 2 minutes. Sometimes 2 minutes can be easier to work with than 5 minutes because you're less likely to be interrupted with 2 minutes. But I think the goal for the rebuttal, ideally, is to not be interrupted, right? To be able to just claim the mantle, and you largely achieved that. But I thought, in terms of just the thinking behind the rebuttal, I thought it was well executed. In Hersh, I thought, there were some great moments in your presentation, too. I found that one of the more effective parts was when you were getting needled by Judge Alba on the exigency, and you went deep on the record, and so all of a sudden there were facts coming out, there was all this stuff, and that was, had an impressive command of it, but it also sort of silenced the critic a little bit because you came at it at a very, sometimes when you're getting questions, one strategy is to go a level deeper, and that was successful, and in terms of just it was successful as a response, but it was also just sort of successful to kind of be able to move on. So I thought, again, I mean, the advocacy we saw from both of you was truly at the highest levels, and you should be both extremely proud of the work that you put in to be able to be here in this final. So congratulations.
I'll also just ask and publicly say thank you to our three judges for being with us here tonight. I know you are all very busy and important people with packed schedules. So can we give a round of applause to our judges, please? Okay. This is the fun part and also the hard part, right? Because I think you both did such a great job tonight. I'm going to ask that when I announce the winner, you please hold your applause until I've finished talking, because I think we both know that both Hersh and Heather should be incredibly proud of what they did here tonight. We're going to hand out the hardware in a little bit. You're both getting trophies. So, at least there's that, right? But in all seriousness, without further ado, the winner of the 2025 McBaine Honors Moot Court Competition is Hersh Gupta. Thank you, everyone, so much for being here tonight. Enjoy your evening. Get home safe. We'll see you next time.